Hello, gentlemen. I am Bhupinder Sharma. I am Chief Legal Aid Defense Counsel at Gurdaspur. I deal with criminal matters on behalf of the state. I mean, legal authorities. So, today I am going to have a short discussion with you on a very important subject, and I have given it the name Key to Cross Examination. Key to cross examination is in fact coined by me just to make a contact between the listeners and so that they can reach me through this channel. My friends, lawyers perform very difficult tasks, right from the drafting of applications, petitions, plaints, affidavits, and whatnot. And then getting on with the business of examination of witnesses, and the most important of all these things is the cross examination. And I assume that all of us who are in the field, who are working as lawyers, advocates, counsel, defense counsel, and who are prosecutors as well, they know that it's not that easy to examine the witness. Even the examination in chief is a very difficult task. We have experienced that, we all experience that every day, that the examination in chief is not that easy as it appears to be. So, I'm not on the examination in chief right now. I am on the cross examination, which is a very interesting subject and is of interest to all of us who are going to be here in the profession as lawyers, as advocates, as prosecutors, as judges as well. Some of my friends who are on the other side of the bar, they understand because they have the first-hand experience of seeing the lawyers examine their witnesses and cross-examine the witnesses of the other side. So friends, let's get on to the business right now. What are the requisites for a cross-examiner? What are the equipments? What tools he need for the cross-examination? It's not something that you just walk in the court and face the witness and start asking the questions. No, it is not that easy, mind you. And those who attempt to do it and those who do it certainly don't do justice to their clients. My dear friends, we are all aware that you need to have techniques for skills and wherewithals for whatever vocation you are in. So even a workman who is doing the repairs of a electrical appliance, he or she knows that he needs a proper tool or proper tools for particular work. Similarly, we also need proper tools or skills. What are those proper tools? Number one, that you must have the complete idea of your case, what your case is about, or what the case is of the other side. So you must have everything on your fingertips. A committed the murder of B on that particular night, which was a dark night, and in the area of such and such place, and it was a forlorn place. Whatever the facts are, or B is not the son of A, and he got executed a will from A by playing a fraud. So you must know the relationship between the parties, how they are placed to each other, how the things developed between them, what led to the main crime or the cause of action for your case. So these are the things which you must know, and you must know in totality, not in parts. I mean, if if you don't interview your client, if you don't ask him the questions, if you don't ask your client how the things happened, or if you don't listen to your client, you will never know his side of the case. So the first and foremost thing is that you must have an interview with your client. You must listen to him. When I say listen to him, not that your mind is somewhere else and you are just saying yes, 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 yes. No. Listening is very important. Listening to your client is very important, and listening to what he says. And don't interrupt him. Mind you, if you interrupt somebody who is talking about something, he or she would forget what he was to tell, or he or she may not tell you what exactly he wanted to tell you. So don't interrupt the client when he is telling you about the story, when he is telling you about the occurrence. So make short notes on your notebook about the case, and so X was interviewed, he told you this thing, he told you this thing, he was at such and such place on the date of occurrence, he had such and such relationship with the deceased, or he had such and such dispute with the deceased prior to the occurrence, or whatever he says, he or she says. So this is one thing, that you must interview your client, and thereafter make and simultaneously make notes of these things. Is it okay? Yeah. So that's okay. We are on the cross examination, so I don't want to hold you back for a long time. Let us get on to the most interesting aspect of the cross examination. So first and foremost thing is, in the cross examination, what questions should be asked, what questions need to be asked to the witness, and second is how we go about asking those questions. So I would say these are the two things: what questions need to be asked, and how do we ask those questions to the witness. And third thing, if I may add, is when to stop. It's very important. Not many lawyers follow the third rule. I would say these are the three rules: what to ask, how to ask, and where to stop. So, gentlemen, first thing is what to ask. So, asking the questions just for the sake of questions is not the purpose of cross examination. As you all know, that the main purpose of the cross examination is to extract the truth from the witness, or what the criminal lawyers do is to create doubts in the minds of the court, which I don't approve, rather. But the practice is that we have to discredit the witness and discredit the testimony which he or she has given. Now, friends, how do we discredit a witness? Witness comes to the court, he tells the court that on so and so date he was there in the company of ABC and such occurrence took place which he had seen, or he had seen somebody stabbing X and then running away, or he had seen such and such weapon being held by A, B, C, whatever. You have to discredit him and discredit his testimony by asking certain questions which you know that he is not truthful. Because when you have examined your client, he or she must have told you about the occurrence or how the occurrence took place, the manner in which the occurrence took place, and so witness was not at the place of occurrence. He or she came to the spot after certain time lapse, maybe 15 minutes, maybe 1 hour, maybe 6 hours. So usually some witnesses are falsely introduced by the prosecution. I'm sorry. So we must know that the witnesses which are introduced by the prosecution and who have not seen the occurrence, their credibility has to be destroyed. Their testimony has to be destroyed by asking questions. So one of the best things is to ask those questions first, those questions which the witness will concede, certain concessions the witness will make, either which are useful to you, which are useful to your case. So those concessions must be extracted from the witness first. And then we go on to the real battle of cross-examination and real kill of destroying the credibility of the witness, and then the credibility of the testimony which he or she has given. So let's see how we can do it. So we all know that the law of evidence is applicable in examination in chief, in cross-examination, and in re-examination. So the first thing, dear friends, is that when the judge says, yes, Mr. Counsel, the witness is yours, that is the time when you start with the questions, and strong questions. Best questions should be asked in the very beginning. How do you ask those questions? Let us see. There are certain tips for that. One is, good questions will be leading questions. I'll explain these things later on. Good questions are short questions. Good questions are simple questions without legal jargon. and you have to maintain the control of the witness. Let the witness be under your control. You are there. You are the fighter. You will draw the battle. The witness is new to the court. So when you are in the court, you are appearing there every day. The judge knows you are so and so counsel, you are such and such advocate, or such and such prosecutor. Advantage is with you. You have to open the armory of your questions. You will ask the questions. The witness has to answer the questions. What type of questions you ask, the reply will be, the reply would be accordingly. So your questions will determine how you win or lose the battle. So friends, I'll take little break and get back to you in a minute. We can do one thing. Let's say this is key to cross-examination 1. So key to cross-examination 2 will be the next video, which we can have in a couple of minutes. Thank you.